Good afternoon, my name is Zuzanna Zarucha and I'm going to get you through the general information and the need of harmonization of pre-contractual obligations under the European Union law. Before my colleagues, Angelika Rasiewicz and Michał Lisowski will give you further information about the duty to act, negotiate in a good faith. It is important to establish whether there has been any degree of harmonization despite the fact that the laws of the member states seem to differ quite significantly. Due to the implementation of the EC directives, such as Distance Selling Directive and/or Package Travel Directive, we can see that there has been indeed some developments related to the requirements of the certain types of pre-contractual information that has to be given before the contract between the business and customer, so-called B2C contracts, is concluded. However, the European Union still lacks the rules on the contracts between the customers, so-called C2C contracts, and between businesses, B2B. If we take a look at the Commercial Agents Directive, we'll see that there is not much said about the pre-contractual obligations, except the fact that each of the commercial agents have to be properly informed before the contract is established. If it comes to the contracts, there are 5 requirements that have to be satisfied before the contract is concluded. There must be an agreement. Each party must give something in exchange. The parties must have the legal capacity to enter into a contract and must do it willingly. The subject matter of the contract must be legal. Next to the directives, there are of course some soft law instruments that contain provisions similar to the ones previously mentioned, such as the Principles of European Contract Law, so-called PECL, or UNIDROIT Principles of International Commercial Contracts. The underlying problem with soft law is that soft law is a quasi-legal instrument which do not have any binding force, and if it does, then in the weaker sense than the one of the hard law, traditional law. What soft law can, however, achieve is some sort of harmonization of practice, if the parties decide to govern their contract by the soft law. But it has to be checked whether it is permissible under the applicable national law. It is important to add that Rome Convention itself doesn't allow to adopt soft law in order to displace the governing national law entirely. As we can see clearly now, harmonization is more than needed.
Hi, my name is Michał Lisowski and today I will present some of the arguments for Commission's position on harmonization of the duty to negotiate in a good faith. Although the negotiation phase was left outside the scope of the instrument, it remains that good faith and fair dealing is a mandatory general principle which radiates through the entire CESL. The emphasis is clearly put on moralizing contractual relationship within the EU. Good faith is very broad and also very flexible principle. Hector Lewis McQueen suggests that one of the positive aspects of good faith, as a general principle, is that it enables the identification and solution of problems which the existing rules do not, or seem unable to reach. Here we can notice the paradox of good faith. It is acclaimed for its flexibility, which permits to provide fair solution and new rules to develop, but at the same time, it is contested for its lack of certainty, which is inherent in such a flexible notion. Paradoxically, certainty can serve as an argument for harmonization of European private law in that field, and now I'm going to explain why. As a part of this law harmonization effort, important task for the Commission is to address the issues stemming from the differences between civil and common law jurisdictions regarding the notion of pre-contractual good faith. Therefore, in my argumentation, I would like to use England as an example. Main reason for the non-recognition of principle of good faith in England is the prevalence of certainty over fairness. And it was clearly illustrated in Chapman and Honig, where it was advocated that parties can exercise their legal rights regardless of the motive. However, we don't see a reason why increasing certainty and fairness cannot be combined. In general, principle of good faith is to be regarded as a principle that has to solve the problem of unfairness. But does it really at the same time diminish certainty, especially in comparison to common law solutions? In famous Interphoto case, Lord Birgham stated that in most legal systems outside the common law world, The law of obligation recognizes and enforces an overriding principle that in making and carrying out contracts, parties should act in a good faith. English law had characteristically committed itself to no such overriding principle, but has developed piecemeal solution in response to demonstrated problems of unfairness. The adjective piecemeal implies that those solutions developed by common law are fragmentary or unsystematic, and therefore harmonization will only transform this piecemeal solution into one coherent instrument and by this increase legal certainty, since practices so far covered under a mythical term piecemeal solution will now be defined and written down. Moreover, such a harmonization in that field is also beneficial for business. While definition of good faith may vary depending on jurisdiction, in case of conflict, it is way more time-consuming when the parties need to acquaint themselves with the way of the notion of good faith is addressed in other jurisdictions. And accordingly, following Benjamin Franklin's maxim that time is money, we should reduce any time-consuming procedure to indispensable minimum.
Hi, my name is Andrzej Karasiewicz, and I'll be talking about the current situation in both the UK and in Germany in regards to the principle of good faith, and more specifically about the principle of good faith in commercial contracts. I'll begin by giving an overview of the current situation in the United Kingdom. At the present moment, the United Kingdom does not possess an overriding principle of good faith. This is because courts have always assumed that parties should have the freedom of contract and that they should be able to negotiate in a free manner and enter into a contract with whomever they desire to. Also, it is held that contractual liability cannot arise unless there is a clear acceptance of the offer. However, more and more we are seeing the principle of good faith in contracts such as employment contracts and contracts where there is a fiduciary relationship. However, for the time being, there is no requirement to act in good faith or to negotiate in good faith in commercial contracts. The UK already recognizes the principle of reasonableness as well as the principle of fairness, and to some extent the principle of good faith can be compared to equity. Of course, the principle of good faith finds its basis in contract law. However, at its core, both equity and the principle of good faith revolve around the idea of natural justice as well as fairness. Furthermore, the concept of promissory estoppel offers sufficient protection against promise revocation or unjust withdrawal from negotiations. Under English law, the same results can be obtained by way of rules that have been developed through precedents. Civil lawyers obtain these results, or very similar results, through the principle of good faith. In general, judges do not like to exert power and determine whether parties have behaved in good faith or not. This is because they prefer to distance themselves from the world of businesses and politics. However, the lack of good faith can be very disadvantageous to parties that have relied on others to their detriment, and more specifically, this could be a hindrance to the internal market. Because of the reasons mentioned, that the United Kingdom recognized the principle of fairness and reasonableness, which resemble the principle of good faith, there isn't so many reasons why the United Kingdom shouldn't be able to adopt the principle of good faith in commercial contracts. I will now move on to Germany and the principle of good faith. Section 242 of the BGB governs the principle of good faith. This provision stipulates that an obliger has a duty to perform according to the requirements of good faith, taking customary practice into consideration. As the provision is broad and somewhat ambiguous, it has given an impetus for the creation of new doctrines, leading to some confusion and unpredictability of the law. This is why the harmonization of the duty to negotiate in good faith in commercial contracts would circumvent the problem that Germany has faced. There would be a specific and concrete provision in regards to how parties should negotiate in good faith in commercial contracts, and this would avoid an unmanageable abundance of case law and opinions. That's it from me. Thank you for your attention.